Hearing in the appeal, London Borough of Southwark and another against Transport for London.
Yes.
May it please your ladyship. I appear with my learned friend Mr. Banner on behalf of TfL, and for the respondent counsels are Mr. Elvin, Queen's Counsel, and Mr. Moles.
Yes. Well, you are to be congratulated, gentlemen, for the economy of your timetable, in that you reduced the 2 days we were prepared to allow you down to a day and a half. But having read your written submissions, they are all so clear and so perfectly set out that it may be that you don't even need a day and a half.
We'll see. I hope my optimism is justified, and of course I'm going to do what I can to honour the aim that we've set ourselves. The issue in the case, I see, has been very accurately described in the note that's been circulated and prepared by, I don't know who, but I can't improve on that as a formulation of the issue in the case, so I won't take up time introducing that. Can I just flag up a point that I'm sure is appreciated by the court, which is that although we are immediately concerned with the provisions of the 2000 order, it is itself modelled on Section 265 of the 1980 Act, which is going to be the focus of my submissions, in the hope that I'll be able to satisfy you that there is no relevant difference between Section 265 and the article of the 2000 order that we are concerned with. The submissions read across. So,
I mention a point. So, I mean, this all has a sort of deja vu quality for me, because back in the 80s, when I was at the bar, I acted for something called the London Residuary Body,
right,
which was concerned with how to deal with the abolition of the GLC. And one of the aspects was the transfer of Greater London highways to the boroughs. And I mean, I don't remember this problem cropping up. I remember all sorts of other problems cropping up. But I mean, was there similar legislation then? And if so, is there any reason to interpret it differently now?
And what did the boroughs get as a result?
What did the boroughs get as a result?
There is some legislation, and I think Mr. Elvin's case refers to parts of this by way of background. We studied it in front of the arbitrator. The difficulty is that the form of the legislation is so unlike the form adopted for this exercise. Mr. Justice Mann did the same exercise in his judgment. It's subject to anything we're told otherwise. I, for my part, suggest it's not productive to attempt that exercise.
No. All right, well, maybe it's, when Mr. Elvin is on his feet, he can just point me in the direction of the relevant bit.
Yes.
But I have a sort of certain personal interest in it.
Yes, these subjects do give rise to a certain amount of recollection, not all of it less than painful. But the issue, the key question, I suggest, in resolving the issue which lies between the parties, the key question for this court, I suggest, is whether the use of the word highway by itself is enough to trigger the top two spits. Let's call it a rule or principle. If I may, my lady, I'm going to call it the Baird principle rather than the top two spits rule, because, of course, Baird makes clear that we're not actually concerned just with the top two spits. We're looking at a column which goes some distance below the surface of the highway and some distance above it, not just the top two spits. But top two spits is the shorthand that everyone is familiar with, so I will probably lapse into using that from time to time. But really what I'm talking about is this Baird concept.
In other words, you don't get the lot.
Exactly. Whatever it is, it's something less than would pass on if we were to step into the shoes of a person who owned not only the top two spits, but the soil and the column of airspace above it. And we say that the critical factor in deciding this question is the meaning of that one word. What weight does that one word carry? Is it enough to communicate the Baird concept on its own? Because that is what the Court of Appeal thought. And that permeates its approach to this question, as I will show you when we look at their decision. We say that the cases which the Court of Appeal relied on to suggest that highway has a general meaning, they call it a common law meaning, are actually engaged with a different question, a completely different question. They're concerned with the interpretation of a particular statutory provision aimed at a specific factual situation. The statutory provision they deal with is what's now Section 263 of the 1980 Act. The courts looking at this were examining the predecessor provisions, but they culminate in what is now Section 263. The factual situation dealt with by all these statutory provisions is this. The authority has come under a duty to maintain the highway, and for this reason alone, some property passes to it. At common law, the people who had the job of maintaining the highway, at common law, the inhabitants of the parish, but let's call them the Highways Authority, at common law, that body had no interest in property at all. It seems that this proved inconvenient, so Parliament began to intervene in the 19th century. And the cases all concern the extent of that intervention. And perhaps unsurprisingly, the courts took a restrictive view about what passed. They looked at the words of the Act, which in each case, although different provisions are looked at, in each case they are linked to the duty to maintain. And this lent the flavour to the interpretation adopted by the courts. Ultimately, the position which emerged treats the amount of land which vests as being commensurate with the duty to repair. The duty to repair applies to something physical. And that has driven and shaped the understanding of highway when it's used in this body of statutory provisions. The courts have also been influenced by a desire not to expropriate without compensation, understandably. So the Baird concept responds not to the question, what does the word highway mean generally, outside the particular vesting provision which applies in this particular factual scenario. Indeed,
well, in common law, the word highway means a way over which the public have a right of passage. That's what the word means at common law.
If I may say so, that is it in a nutshell. If you need the common law to tell you what highway means, you get a description of the legal right.
It's an incorporeal right.
I beg your pardon?
It's an incorporeal right.
An incorporeal right, yes. Belonging to
The public.
the public. And I can go a little further. I can say, so far as I'm aware, this general question of what is the general meaning of the word highway has never been asked beyond the extent that to which my lady has just referred. Now, this is important because as I've said, the modern successor to all of those provisions is Section 263, not Section 265. 265 has a different provenance, which we've set out in Annex 1 to our case. Now, obviously, the arbitrator and Mr. Justice Mann agreed with us. They also recognised that the transfer order and the trunking provisions serve completely different statutory purposes from Section 263. And they also recognised that these different purposes would be impeded by the Baird concept if you have to import it from Section 263. Can I just flag up, my lady, that we have asked, and I do ask you to read not only Mr. Justice Mann's judgment, but also the arbitrator's award, or the passages of it we've mentioned, because it does have some insights which aren't fully captured by the judge's summary. I'm going to show you the key parts, but in case I sort of forget any, I have flagged up the relevant paragraphs at the start of our case.
It's a good read.
It's a good read. It repays the reading.
Whether it's right or wrong, it's a good read.
It may be that your ladyship has already pre-read it, in which case I need to say nothing more. But obviously the Court of Appeal disagreed with the arbitrator and with Mr. Justice Mann. It said that the cases that I've described present a formidable body of authority showing that the word highway has accumulated a meaning in the bared sense. And they actually go so far, as I've said, to suggest that the highway is a word having a common law meaning. May I emphasise, perhaps I'm repeating myself, but this is a very radical proposition. First of all, it's never before been suggested in any case that I know of. Secondly, as I've said, I'm not aware that any court has purported to offer such an ambitious definition. Thirdly, as I've said, the root cases, when we look at them, actually relate to different nouns, street and road, not even highway at all. And fourthly, the authorities make clear that the bared concept emerged out of a consistently purposive approach to interpreting the effect of the particular statutory provision that I've described. Let me then, my lady, show the court, remind the court, how vital to the Court of Appeal's reasoning is this radical idea that the word highway itself communicates the bared concept. The judgment is in the core volume. It starts at memory stick page 142. And can I remind the court of what is said starting at paragraph 2 under the heading meaning of highway? The whole approach is to look at highway as a word.
Which paragraph are we on?
22, sorry, I jumped ahead to page 147 in the memory stick numbering, paragraph 22, heading meaning of highway, which gives you the clue that the Court of Appeal is looking at highway as a word. No statutory definition of highway looked at as a word in paragraph 22, necessary to have it regard to its meaning at common law. And then, in fact, the extract quoted makes the point that my lady made just a moment ago. What you've learned from the common law is that highway is a description of a legal right, not anything else. But
and the physical piece of ground over which that right exists.
Exactly. What the public has a right to pass and repass over. There's then reference to Benyon, and I call attention to the last part of that. The concept of a highway long predates highways legislation under common law. Highway may be broadly defined as a way over which all members of the public have the right to pass and repass. Nothing beyond that, so far as the common law is concerned. In paragraph 24, the Court of Appeal, I suggest, we can see the Court of Appeal beginning to make what I say is this important mistake. The meaning of a highway and the extent of property included in a highway has been considered in several authorities. The historical background and the restrictive approach of the courts to the extent of property comprised in a highway is well explained in Sovin. Can I say in a nutshell, that way of putting it immediately reveals the error that I complain of. These cases don't talk about the extent of property comprised in a highway. They talk about the extent of property which vests in the highway's authority in the factual situation I have described. That's a different thing. I then refer to paragraph 33.
I mean, that's the point that's made at the top of the next page from Sovin, isn't it? Courts being first.
Yes.
Tried to analyse the nature of the interest vested, which was a different issue.
Yes, I'm going to show you the three questions that the courts had to answer in the 19th century. we're only concerned immediately with one of them, but the other two have an important part to play in understanding how this issue has emerged. Then in paragraph 3, the Court of Appeal said, does your ladyship have this at page 150? These and other authorities represent a formidable body of authority that when legislation vests in a highway authority, a highway or a road or a street for the purpose of its maintenance as a public highway, the authority doesn't become the owner of the freehold interest in the entirety of the land on which the highway runs, but only of the surface and such part of the soil as is necessary for the maintenance of the highway. With that proposition, I don't quarrel. But what comes next is the mistake. That is the common law meaning of a highway. That goes too far and is unsupported, in fact, by the proposition that the Court of Appeal has just given. And your ladyship appreciates the importance of this point. The Court of Appeal is setting up a presumptive meaning of the word highway, which it becomes my job to displace. It becomes yet clearer when we read on. If we see in paragraph 36 the summary of the judgment of Mr. Justice Mann, the judge summarised the submissions of Mr. Elvin for the councils. Before the judge, as before us, Mr. Elvin relied on the generally understood meaning of highway derived from the cases above. The last sentence. And he submitted that it should be given the same meaning as the transfer order as it bears in the 1980 Act. He relied in particular on sections 263 and 265 of the 1980 Act. Given the similarity of wording between section 265 and Article 2 of the transfer order, consistency required that they be given the same meaning. Pulling all his points together, Mr. Elvin submitted the case demonstrated a degree of consistency as to what vested in highways authorities. Was that enough of the... Can I then ask you to go to paragraph 46 on page 153, where the Court of Appeal has taken as its starting point Article 2 of the transfer order in the preceding paragraph, and then they say the use of the word highway is significant. The authorities to which I have earlier referred have established its common law meaning as the surface and the subsoil necessary to its use as a highway, and so on. Transfer in relation to each GLA road of the highway suggests that the intention was to transfer no more than that. Given the long-established and restricted common law meaning, it's an odd choice of word if the intention was to transfer. Your ladyship sees from the rest of that.
Dedication as a highway didn't transfer anything.
Quite. Exactly, and it still doesn't in and of itself.
No.
But conversely, if you compulsory acquire land under your highway powers to build a road,
You get the whole lot.
you get the whole lot.
Exactly. Yep.
And that's a point that Mr. Justice Mann makes, that
Yes.
you can have things vesting in the authority in many different ways.
The point we've made in our case, but both the point made by my lady and the point made by my Lord Carnworth point instantly to the fact that the word highway, as used in the legislation, has a protean quality. You can't take the meaning it's received in section 263, which deals with this highly specific situation, and generalise from that to create a presumptive meaning which has to be displaced where you see the same word used otherwise. May I say, I'm not suggesting that there is a general meaning of the word highway. That's not part of my case. My case is that in each situation where the word highway is used, potentially the court will have to reflect on what is meant by that, and I'll develop that in due course. But if I can just complete this exercise of reminding the court of the importance of this idea that it's the word alone which has a common law meaning, which is sufficient to attract the bared concept, may I also go to paragraph 52? The last 4 lines, I think, are sufficient for my immediate purposes. This is on page 154. Against the background of the well-established common law meaning, it would be extraordinary for the draftsman to use the same word in both sections without any indication that they are intended to carry very different meanings. And then I suggest, quite importantly, in paragraphs 43 to 45, can I take this from the top of page 155? There's no suggestion here of highway carrying anything other than its ordinary common law meaning. We then find how the Court of Appeal rejected Mr. Justice Mann's purposive view of the Act. And I want to show you this bit because this is the reason why the Court of Appeal rejected the stepping into the shoes argument. They set out what Mr. Justice Mann had said in paragraph 54, and then in paragraph 55 they explain why they reject it. The difficulty I find with this approach is that it attaches little or no weight to the words chosen, deliberately one is entitled to assume in these provisions. In particular, it regards as virtually irrelevant the repeated use of highway. If the intention was as the judge considered, it could with no less difficulty have been spelt out. And then there's reference to what Lord Holsbury said in Tunbridge Wells and Baird, if the complete vesting of the whole of the property in the land over which the public had rights or duties of repair were intended to be given, there would be no reason in the world why the legislature should not have said so. Rather than spelling it out, the draftsman has chosen to use a term that generally carries a meaning at odds with the policy identified by the judge. You see the continuing importance of this point at the end of the paragraph. I don't think they're capable of bearing the weight put on them by the judge and of showing an intention to vest land qua hire authority, whether the surface or a wider holding, particularly when the draftsman has used the word land in contrast to highway in subparagraph A. So we respectfully suggest that it is critical to the Court of Appeal's reason that it's this word highway which does the job, is sufficient to do the job of engaging the Baird concept on its own. My lady, I've now told the court what we say is not communicated by the word highway on its own. I've indicated to the court that I'm not going to suggest that I can offer you a general meaning, but I do need to show you or tell you what meaning we say the word highway has in the provision we are concerned with. It's already clear, actually, from the formulation of the issue that's being prepared by the judicial assistant. One can put it in different ways. One way is to say highway in Article 2 and paragraph A of Section 265 describes the route over which the public has a right of way, a right to come and go. You can also find in the authorities at least two dicta which use the same form of words, even in relation to Section 263. We've drawn attention to Lord Justice Fry in the Court of Appeal in one case, who thought, well, if he was starting with a clean sheet of paper, he would have said that even the Baird concept meant, and these are his words, the area covered by the street, in other words, everything beneath and above the superficies of the street. I'll come back to that when I look at the cases. In another case and in another context, Lord Clyde has used these words, the stretch of land over which people may pass. If we delve into the Act, we find a definition of proposed highway, which talks about land on which it's proposed to build a highway. Well, if you take away the word proposed, you're left with land on which there is a highway. I only make those points to emphasise that the meaning we ask the court to adopt is not a strained or unnatural meaning of the word highway. It's perfectly natural to speak of a highway in the way we ask you to accept the draftsman has used it in our case. And we do ask you to be particularly on guard against reading across from Section 263 to Section 265 for a reason that was mentioned by my Lord Carnworth in the Court of Appeal in a case of Mitchell, which is the first I want to show you, just for this point, if I may. This is in Mitchell and Department for Transport, 2006, 1 Weekly Law Reports, 3,356, which is in volume 3 of the authorities at tab 30. The memory stick number is 2049.
2049.
2049.
You don't need to tell us what the law report reference is, Mr. Morsehead.
Sorry, I won't do it again.
We do need to have the
memory stick number.
Memory stick and the volume and tab number.
I should have said the case report starts at 2044. The passage to which I wanted to draw the court's attention is at 2049. The case concerned how much does the Highways Authority's duty to repair bite on? What is covered by that duty? And we see the statutory words at page 2049 in paragraph 14 of, as he then was, Lord Justice Carnwath's judgment. Section 41(1) of the 1980 Act provides the authority who are, for the time being, the highway authority for a highway maintainable at the public expense are under a duty to maintain the highway. At paragraph 16, Lord Justice Carnwath refers to some of the points made in argument. He said, reference has also been made in argument to the specific provisions dealing with drainage, and he gives some examples. He said, I don't understand it to be suggested that this specific provision is in itself inconsistent with a more general duty under section 41. We have also been asked to note the contrast between maintenance duties and road humps and powers in respect of such things as barriers. It's suggested that the distinction is at least illustrative of the limitation of the duty to repair to the surface of the highway. I say at once, in an act with as diverse a pedigree as the Highways Act 1980, I see little value in detailed textual comparisons of that kind. And I say that it's not the same danger, but a similar danger emerges in this case. It would be wrong, for the reason given by my Lord Justice Carnwath, to assume that one can safely read from section 263 into section 265. The pedigrees are completely different as tabulated in the annex to our case.
Is there not, I mean, I'm interested to be reminded by what I said there, which I'd forgotten, but is there nothing in Benyon about this in relation to sort of jumbled statutes, if I can call it like this? It's not really a sort of, we've got a whole different sources of the legislation.
That's true. The best and most nuanced description of the principle actually appears in a case called Goods in the House of Lords, which your Lordship actually referred to in Mitchell. But if you'd like to be reminded of what was there said by Lord Hoffman, I think this is probably the best way of doing it. This is in the supplementary authorities volume at tab 39. Oh.
Do we have it electronically?
Yes, I think you do. I'm sorry. It's
2224.
2224.
2224.
Oh, well, we don't have that in the... No. But there may be another one.
Has it come on a separate? They may be on a separate.
I'm sorry. I hope that the electronic version can be updated.
Well, it only goes up to 2218.
Probably a separate file.
I'm told it came through as a separate PDF. I'm such a troglodyte that I don't use the...
Well, if so, it hasn't been uploaded onto our machines. Can you find out from IT, please? Thank you. Never mind, we can actually look at hard copy for a change.
Well, I'm only going to this case to answer my Lord Justice's
Yes, I mean,
point.
it's making, we can come back to it later.
It's really, if I can make this note, in the typed report, it's page 1359, from letters E to, I suspect you will want to read down to 1360H, probably.
Oh.
And what you will there find is Lord Hoffman recognising substantially the point that my Lord Justice Carnwath made, but then recognising that there might also be exceptions to that, where the only way of understanding a particular provision is to look at the history of the provision in question. And it's only by looking at the statutory history of the provision which was construed in the Goods case that its true meaning was identified. And so although that's a long-winded way of answering my Lord Justice Carnwath's point, I think that is the most authoritative description of the sort of the process that's appropriate. But we can go back to Benyon and see if it's put more succinctly somewhere.
Thank you.
My lady, the outline of my submissions is this. First of all, I'm going to have to show you some of the cases, I think. And my main object will be the one I've identified, show you that what they answer is the narrow question I've already explained. I will then show you the limited statutory definition of highway that we've got, which is in section 328 of the 1980 Act, as well as section 263 itself, with some of their background material. It's at that stage, my lady, that I'll turn to section 265, because really the points of contrast and comparison that are at the heart of this argument will only really make sense once you've seen that other material. I'll also have to say something about this case of Bayliss. I'll then do a sort of cross-check with Article 2 of the 2000 Order, and only if time permits will I develop what I've said in my printed case about the problems which arise even with the Baird concept, even in the context of Section 263. That's something of a deluxe point.
It's deluxe, I think, because you more or less accept that in 263, highway does have the meaning for which the Court of Appeal proponents.
My only reason for referring to the difficulties is this is another reason why one shouldn't hurry to import those difficulties into Section 265. That's the only reason for going through them. So that's why I say it's a deluxe point. So, lady, turning then to the authorities. At common law, what is now the Highways Authority was previously the inhabitants of a parish. They had an obligation to repair the highways in their parish, but as I've said, this didn't give them any property interest whatsoever. This is the point summarised in Mr. Sovin's book, which is at memory stick 2184.
And for the dinosaurs amongst us?
Beg your pardon, my lord?
Volume 3.
Volume 3, yes, sorry. Yes, it's volume 3, tab 34, MS 2184. And it's the point he summarises starting at 2187, under the heading Legal Interest of the Highway Authority at Common Law. In the first paragraph, he makes the point that I have just made. And then halfway down the page, just below the quotation from Good Title, he makes this important point: it was left to statute, therefore, to create an interest in land, which was held by the body on whom the duty to repair had fallen. Now, the courts in the 19th century construed these statutory interventions, and it turned out that they had to answer 3 questions. Let me identify them. First, does the statute confer on the authority a mere right to control land, or does it also confer a property right in land? That was the question in Coverdale and Charlton, which held that the authority acquired a property interest in the land. The second question was, does the authority's property interest survive a cessation of highway use? Or does the full property interest revert to the previous owner and its successors? This was answered in the latter sense, there is a reverter, in Rolls and Vestry of St. George the Martyr. And this is the origin of the idea that what you get, if you're the Highways Authority, is a determinable fee simple. Now, this case is also important because it contains dicta of Lord Justice James, which Lord Holsbury later considered relevant in relation to this third question. And the third question is the one we're now interested in. How much property vests in the authority? This did not matter on the facts in Coverdale because it was enough for the surface to have vested. But despite that, the judgments in Coverdale contained some quite wide-ranging and, as it turned out, influential dicta. But the first case where the question mattered was Wandsworth Board of Works and United Telephone Company, and the approach there taken set the stage for what became endorsed by the House of Lords in the Baird case. So that, in a nutshell, is the shape of the key authorities decided in the 19th century and a description of what they actually decided. Now, I don't really want to exhaust my time or anybody's patience by trawling in too much detail over these cases. It would also be, I suggest, unproductive to do so for two reasons. First, my main point is the negative proposition about what they don't do. And in a way, without shirking my responsibilities, if I've missed something, then I'm sure I'll be corrected by Mr. Elvin later. But the second reason is that, as we'll see, later cases tend to summarise earlier ones. So we end up, as it were, rereading quite a lot of what has already been said. So I hope I get the balance right, because having said all that, I do think I need to show you certain key passages. And I think I need to start with Coverdale and Charlton. This is at memory stick 1748, otherwise to be found in volume 2, tab 15. My lady, the immediate issue in the case was whether the Highways Authority, by reason of this vesting provision, had enough title to allow somebody else to graze on the surface of this grass highway. And that's why I said earlier that it was enough to decide that it was the surface which vested. The first judgment to be given in the Court of Appeal, let me show you first 1754, where we find at the foot of the page a quotation from the statute being construed, the Public Health Act 1875. Section 149 is what the court was concerned with. All streets being or which at any time become highways reparable by the inhabitants at large within any urban district, and the pavement stones and other materials thereof, and all building implements and other things provided for the purposes thereof shall vest in and be under the control of the urban authority. Lady, can I make my submission about those words like this? That form of words tells us straight away to expect that what vests is going to be a corollary of and commensurate with the duty to repair, which is here described as being the trigger for the vesting. That's what one would expect. That is the purpose of this provision. Something physical is implied as the subject matter, something that can be repaired. Lord Justice Bramwell gives the first judgment starting at memory stick 1759. I'm not going to invite you not to read any of it, but if I can sort of make my point about what he says in 1759 to 1760, it would be this. The Lord Justice conscientiously agonises about this issue. At the foot of 1759, I have my misgivings as to the meaning of the word vest. He finds it very difficult at the top of 1760. About a third of the way down the page, on account of the reasonableness of such an interpretation, I'm disposed to hold that this street vests without any property in the freehold of the soil. Then he, as it were, he equivocates somewhat about this. The word vest may have two meanings. Most of his judgment, in fact, is taken up with the meaning, as he sees it, of the word vest. About two-thirds of the way down the page, he says, I cannot make up my mind to say, that is the meaning of the word vest.
This is very refreshing, isn't it?
It is. It's candour. It's judicial.
Judges not being able to make up their minds.
And he says that Mr. Justice Willis referred to numerous authorities, none of which are enumerated in his judgment.
Yeah.
She says do exist.
So I mean, one doesn't want to be too glib about this, but it can be seen that this topic was recognised as a difficult one, even in relation to what is now section 263, right from the start. And at the foot of the page, the judge comes down in favour of what became, if I can put it this way, it morphed into the Baird concept. Does your Lordship see the inconvenience and injustice of holding that the word vest would have that broad effect? He was talking about vesting minerals and so on. The inconvenience and injustice of holding that the word vest should have that effect prevents my putting that construction upon it. What is the meaning? The legislature might have used the expression transferred or conveyed. Can I just park that point? I'll come back to it in a moment. Transferred or conveyed, but they've used the word vest. The meaning I should like to put upon it is that the street vests in the local board qua street. Not that any soil or any right to the soil or surface vests, but that it vests qua street. I find some difficulty in giving it a meaning, and I do not know how far it adds to the words shall be under the control of. The meaning I put upon the word vest is the space and the street itself, so far as it is ordinarily used in the way that streets are used, shall vest in the local board. Again, I'll show you anything my learned friend thinks it's helpful to you to see at this stage, but for my part, I'd like to go to 1762, about 3 lines down. I think by now the judge is making up his mind. That would show that a street comprehends what we may call the surface. That is not a surface bit of no reasonable thickness, but a surface of such thickness as the local board may require for the purpose of doing to the street that which is necessary for it as a street, and also of doing those things which commonly are done in or under the streets, and to that extent they had a property in it. I think that's where he settles.
You missed out what he said at the middle of 116, or 1760, about it, the idea that it vests everything above and below as being such a monstrous thing to say to be necessary for the proper control of the streets by the local board.
Yes, that is the purpose. The purposive approach that the judge took was based on this idea that it would be monstrous to expropriate all this property from a private landowner without compensation. That's the idea that he has in mind. That's the key influence. I mean, I'm grateful to my Lord. We see it more clearly in other cases, but that is in it's not in the back of the minds of these judges. That is powerfully at the front of their minds. Lord Justice Brett gave a judgment starting at 1763, and he too, at page 1764, concentrated on the meaning of vest in. I think one can go to the bottom of 1764. When we've decided that the words vest in mean to give a property in, a further question would be, in what does it give the property? That must depend upon the subject to which those words relate, and that is not land, but street. The section does not say that the land shall vest in, but that the street shall vest in. My lady, this point is emphasised also in other cases, but also by Lord Millet in the Privy Council in a case called Blanchfield, which the Court of Appeal has referred to. So I'll have to come back to this in a moment. The point being made is that there's a difference between street and land. And I think what Mr. Elvin and the Court of Appeal would say is, well, if the intention was to vest not only a layer, but also the land on which this layer was situated, it would have used the word land rather than street. And I think Mr. Elvin will get support for that submission from those words. That perhaps is one of the high points of the submission. And reading on, we see on this page, so here the words of this section vest the property in the street, and the street does not include the houses by the side of the street. It includes the space between the houses, which is used as the footway and roadway, and so on. But then we come to what I suggest is the key point behind this approach that's taken to the word street. It's 2/3 of the way down the page. Does your ladyship have...
Which page is it?
1765, I'm so sorry, 1765. Does your ladyship have the words, if the enactment gives the local board?
Yes.
If the enactment gives the local board that property in so much of the land, it gives them the absolute property in everything growing on the surface of the land. The legislature have, because the rights of owners to the soil in a street is of so little value, intentionally taken away that right and given it to the extent I have mentioned to the local board. He's making the expropriation point. The only bit, he's saying, which has been taken without compensation is the bit which is worthless. So, like Lord Justice Bramwell, Lord Justice Brett is strongly influenced by this concern against expropriation without compensation. Lord Justice Cotton gave a judgment starting at 1767. In the first main paragraph of his judgment, he correctly isolates the particular issue that they had to grapple with. It's sufficient for the purposes of the present case if they had any right to the property on the surface of this lane. That is correct. And that's why, strictly speaking, what is said about the extent of the vertical column is obiter. Because however far the vertical column goes, it certainly included the surface. But nevertheless, what is said by the judges in this case, has been influential. Of course, I acknowledge that. The judge, Lord Justice Cotton, again, directed himself on a purposive view about what was the intention of this act. We see this coming to a head at page 1770, at the end of the main paragraph on this page. Therefore, on the true construction of this Act of Parliament, the meaning to be given to the words vest in must be passed to and vested in the local board. It is sufficient in the present case to say that the street and the surface vested in the local board some property in the soil for the purpose for which it was to be used. And in my opinion, I was told that the street is a material thing and that under this clause it vests in the local board. So I say one can take from Coverdale and Charlton the point that right from the outset, the courts have taken a purposive approach to understanding what is now Section 263 and all the words that appear within it. I've also drawn attention to the distinction between vest and transfer. It's not entirely clear what he thought was the difference, not from what he has said. I'm going to make a suggestion later, which I will back up with one authority that I've found. But can I flag up now what the distinction might be that he had in mind? If one compares the word transfer with the word vest, there isn't a difference which immediately stands out. But if one reflects on it, one can accept that the word vest has more potential to create new interests where none previously existed than the word transfer. Transfer more strongly implies than vest that what is passing is something that already exists. I don't say that it's an absolutely concrete point, but that may be what the Lord Justice had in mind. And we might get some hint in support of that from a much later case, which I'll show you in due course. The next authority is...
All that was decided in this case was that the authority had sufficient interest to let the grazing rights.
The next case is Rolls and Vestry of St George the Martyr. This is Volume 2, Tab 16, Memory Stick 1772. And this case, as one sees from the head note, was not about the extent of the interest which vested physically, but whether it was a full fee simple or only a determinable fee. And the decision was all that vested under this provision was a determinable fee. I believe it's going to be sufficient for me to show the court that passage from the judgment of Lord Justice James, which was later approved by Lord Holsbury. This starts at page 1782 in the manuscript numbering. He refers to Coverdale and Charlton, and he says, what that case decided, and all that it was necessary to decide, was that something more than an easement passed to the local board, and that they had some right of property in and on and in respect of the soil which would enable them as owners to bring a possessory action against trespassers. Now, what was that something more? It's impossible, he says, to read any of the three judgments delivered on that occasion without seeing that in the view of the learned judges, the soil and freehold in the ordinary sense of the word soil and freehold did not pass. That is to say, the soil from the centre of the earth up to an unlimited extent in space did not pass, and that no stratum or portion of the soil, defined or ascertainable like a vein of coal or stratum of ironstone or anything of that kind passed, but that the board had only the surface, and with the surface such right below the surface as was essential to the maintenance and occupation and exclusive possession of the street, and the making and maintaining the street for the use of the public. Then if that were so, and if the word street did not include the whole of the soil and freehold measured longitudinally by a certain number of yards, and latitudinally by a certain number of yards, the street being nothing but the mode by which you ascertain dimensions, then the word street in the Act is not to be applied in what would be the ordinary sense of the word street in a conveyance, if there be in truth any ordinary legal sense of the word street as a description of property to be conveyed, which I'm not satisfied that there is. That's quite a complicated sentence, but unpicking it, what he's saying is you don't, in this section, take the ordinary meaning of the word street, but actually, he says, I don't accept that there is an ordinary meaning of the word anyway. So that's all that's being said there. But if it is competent to limit the extent of the right of property by reference to the general purview of the Act of Parliament and the purposes for which the thing is vested in and given to the public authority, it seems to me it is equally competent, equally right, and equally reasonable to limit that right in point of duration. Milady, that is the critical passage, because you see plainly the purpose of approach that's been taken. If it is competent to limit the extent of the right of property by reference to the general purview of the Act of Parliament and the purposes for which the thing is vested in and given, i.e. without compensation, to the public authority, he says it must follow that the same is true in relation to the duration of the interest which passes. And he emphasises this point in the foot of the page. It seems to me very reasonable, then, to interpret this enactment in a way which gives everything that is wanted to be given to the public authority for the protection of the public rights, without any unnecessary violation of the rights of the landowner. And to say that according to its true construction, what is to vest is not those pieces of property which have now got the name and are distinguished by the name of streets, but those things which now or at any time hereafter shall, for the time being, be streets and highways within the district. And this is what creates the idea of a determinable fee simple. Unless my friend thinks it would be helpful, I don't propose myself to go to any of the other judgments. I think that's the critical passage. The next decision I need to show the court is Wandsworth Board of Works and United Telephone Company. This is in volume 2, tab 17, memory stick 1794. And it's here that we find authority for the proposition which until now has been touched on, but only as obiter, which is a fuller description of the vertical column of land which vests under these provisions. And we discover that however high it doesn't go high enough to let the Highways Authority sue a telegraph company for trespass when they hang their wire a certain height, I think it was 37 feet above the highway. The first judgment is given by the Master of the Rolls, who by now was Lord Brett. His judgment starts at page 1799. It is a long judgment. Again, unless my learned friend thinks I'm missing something that at this stage it's important for you to see, I suspect I can go straight to 1803. Where he comes to the question which arose also in Coverdale: what is the meaning of the word street in this Act of Parliament? Because what vests in the Board of Works is in terms the street. What is the street? And you see the arguments that are there set out. And we find, as I warned us, that there is a fair bit of recycling what has been seen in earlier cases, including Coverdale and Charlton. I think one can then go to page 1805, about halfway down. Does your ladyship see the reference to Lord Cook in Cook on Littleton at 4A? Where a piece of land is granted or is conveyed in England by a grant from the king or by a conveyance from party to party, under the word land, everything is passed which lies below that portion of land down to what is called the centre of the earth, which is, of course, a mere fanciful phrase, and usque ad caelum, forgive me if that's a wrong pronunciation, which to my mind is another fanciful phrase. By the common law of England, the whole of that is transferred by the grant or the conveyance under the term land. But I'm of opinion that it doesn't follow that in a grant or conveyance the word street would produce the same result. I'm not clear about that, but even although it would have that effect in a grant or a conveyance, that is not the question here. So just pausing there, I think what the Master of the Rolls is saying, that he doesn't accept that a grant or conveyance of the street would also carry the land, but he's assuming that it would. Assuming that it would, he says that's not the question anyway. The question is, what is the meaning of the word street in the Metropolis Management Act 1855? And when we're dealing with the meaning of it in that Act of Parliament, we consider, and again your ladyship sees straight away, this purposive approach being taken. For what purpose that Act of Parliament was passed, and with what and with whom it is dealing. And we see the sorts of points that I've already emphasised being made. I believe I can go now to the judgment of Lord Justice Bowen, who obviously agrees. It's an interesting judgment because we find at page 1810 an early formulation of what we might now recognise as the iterative approach to interpretation. If your ladyship sees below the reference to Coverdale and Charlton, assuming that something physical is meant to be vested, we still have to construe both the term vest and the term street. Now, to my mind, when in a section of an Act of Parliament the expression occurs that a street is to vest, it's impossible to advance very far by taking the term vest by itself and asking oneself what it means. The true method of construction is to ask oneself also whether any light is thrown on the word vest by the fact that the statute is dealing with the word street, and whether any light is thrown on the word street by seeing that the word vest is used in regard to it. We have to see what the Act of Parliament meant by the combined expression, and his conclusion is consistent with ultimately a bad concept. He also, the whole judgment, of course, repays reading, but he does return to this purposive approach at the foot of page 1813, reference must be made to the Act to see what it means, and I think it was not within the purview of any possible object of the legislature that a public body in this country should be invested with more power of interference with the exercise of private enterprise and adventure than was really necessary. It's the expropriation point again.
Sorry, where do we see that?
This is at the foot of 1813 going over to 1814.
Yes.
The judgment of Lord Justice Fry, I think I need only go to just to locate that passage that I have relied on in the case. It's at page 1815, halfway down the page. Does your ladyship see the words, if the matter had been? If the matter had been entirely uncovered by decision, I'm not certain that I might not have come to the conclusion that the safer view was this, namely, that the statute intended to vest as land with all its rights the area which was covered by the street. In other words, everything beneath and above the superficies of the street, but that proposition hasn't been argued before us, and he says that Coverdale would be inconsistent with it. I suppose the other point that might justify the court's dwelling a little bit on what Lord Justice Fry says in his judgment is that he describes on this page and on the following page one of the complications that arises from the Baird concept. You have to describe different zones in this column. You have to describe what he called the area or zone of ordinary user. This has no identifiable parameters because the Baird concept doesn't confer anything with a fixed or identifiable boundary. It's inchoate, it fluctuates depending on the needs of the highway at a time. But never, so you've got this zone of ordinary user, and then sitting above it, says Lord Justice Fry, is another zone. You see halfway down the page. There will be another zone or area from which a possible interference might take place. And on his view, although because he's bound, he thinks, by Coverdale, to apply the Baird concept. So although the authority doesn't own that zone, nevertheless, somehow it has a right of control over it, where what goes on there interferes with the highway. So the concepts that are generated by Baird are quite complicated and nebulous. I'm not attacking that. I can't attack that. But I do say this is a reason for, it's illustrating the point I made to Lord Briggs earlier. It's a reason for not extending the Baird concept unnecessarily, unless you're driven to do so. Then we come to the Baird case itself. And my lady, this is in volume 2 at tab 18. The memory stick number is 1819. And the question was whether the Highways Authority had sufficient title by reason of this vesting provision to put lavatories underneath the street, which had vested in them. The key passage is actually quoted by the Court of Appeal in our case, but if one goes to 1822, one sees it here set out. And unless your ladyship would like me to do so, I don't myself propose to read it to the court. I invite you to cast your eyes over it. What emerges is an endorsement of what Lord Justice James had already said. It's the same approach being taken. I ought to draw your attention to what he says at the bottom of 1823, because he refers to that passage from Lord Justice Fry's judgment that I have mentioned in my case. Does your ladyship have these words? Lord Justice Fry says he thinks it might have been the safer view if that had been adopted. Whether his lordship means the safer view in a court or the safer view to be taken by the legislature so as to make it plain to be their intention that the soil should pass, I don't know. I invite the court to take its own view of that when I read what Lord Justice Fry said, I have to say it's quite clear what he meant. He was saying that the interpretation of what is now Section 263, and which he would have preferred, would not have given rise to all these difficult points. Lord Herschel's judgment speech, unless my own friend wants me at this stage to go to anything else. No. Lord Herschel's speech on page 1825, starting on page 1825, is also important because he offers the summary of the top two spits principle, which is authoritative or most authoritative in my submission. And I think the Court of Appeal has said this as well. But at page 1826, you see about two-thirds of the way down the page, Section 149 vests all streets being or becoming highways reparable by the inhabitants at large and the pavements, stones and other materials thereof. All that. So he's noticing the linkage between the repairing obligation and the words streets and vest. That's the point he's making. All that seems to point to the surface use of the street as a highway and nothing more, and I'm unable to see why it should be supposed to transfer to invest in the urban authority the subsoil and so on. He asks, and so we come to, he asks himself, what is the necessity for transferring anything else for these purposes? There isn't any, he says. And then at 1827 is the passage that is authoritative on the top two spits principle. The vesting of the street vests in the urban authority such property and such property only as is necessary for the control, protection and maintenance of the street as a highway for public use. I don't think I need to show you Lord Norton's speech. So those are the core authorities. There are others, but those are the core ones. I need to show you three others just to complete this part of the picture. The first is Finchley Electric Light Company and Finchley Urban District Council. This is in volume 2 at tab 21. MS 1845. The factual nuance in this case is that the vesting provision which we've looked at came to be applied in relation to a highway situated on land that had previously been a turnpike.
Previously been a
Turnpike.
Oh, right.
And so it was vested in trustees who had previously held, it's a slightly loose way of putting it, but broadly speaking, a quasi-highways function. It's not quite a highways function because a turnpike isn't quite a highway. The public doesn't have a full and free right to use a turnpike. It has to pay for the privilege. But at all events, Mr. Elvin is entitled to say that the land was vested in trustees who held the land and acquired it originally for, let me call it, this quasi-highways purpose. Now, in Finchley, the urban authority argued that because of this history, when the time came for the highway to vest in them under Section 149, they got the whole of the vertical column, not just the top two spits. And so the factual difference in the history made all the difference in law. And the Court of Appeal rejected that view. And in the Court of Appeal, I think Mr. Elvin said, well, that's analogous to the situation we face in our case, where we're transferring from a current highways authority to an outgoing authority, so to speak, to an incoming authority. The problem with that argument appears from the judgment of the Master of the Rolls, Lord Collins, starting at 1847. He sets out the facts. He describes the history of the ownership. But he then describes and emphasizes what happened about just under halfway down the page, does your ladyship have the words, then the local authority come in?
So which page?
We're now on 1848.
Yeah.
Then the local authority come in under section 149 of the 1875 Act. There's no doubt that this street had become a highway reparable by the inhabitants at large, and therefore the right conferred by section 149 upon the local authority existed. That right is that the street and the pavement stones and other materials thereof and so on shall vest in and be under the control of the urban authority. It has been decided by a long series of cases that the word vest means that the local authority do actually become the owners of the street to this extent. They become the owners of so much of the air above and of the soil below as is necessary to the ordinary user of the street and of no more. He then explains the basis for that by reference to Coverdale and Charlton. This is at the foot of the page going over to the top, that in construing an Act of Parliament which confers a right upon a public authority for which they don't pay, the court gives the best effect to the intention of the legislature by limiting the right to the area which is necessary to enable them to perform the duties imposed upon them in respect of the street as a street. And he summarises the position halfway down the page. The conclusion to be derived from the authorities seems to be this: all the stratum of air above the surface and all the stratum of soil below the surface, which in any reasonable sense can be required for the purposes of the street as street, belong to and vest in and belong to the local authority. That being the law which is settled, it's said that in this particular case the local authority got something more than that. And he says the judge at first instance accepted that, but he disagrees. He then sets out the judge's reasoning. But this is the critical passage. If we now go to 1850, about 8 lines down, it seems to me that the standard which determines this question of how much vests, is not how much the owner has to give, but how much the local authority, under the Public Health Act, have the right to take. It doesn't seem to me that that which is given to them by the Act of Parliament, by virtue of their position, becomes any larger or smaller by reference to the ownership of the soil below. That's, if I may say so, an entirely unsurprising conclusion. He's saying the effect of section 149, the effect of this vesting provision, isn't ambulatory. It doesn't depend on what interest in land you apply it to. The construction adopted by the courts of that section applies in every situation, every factual situation. That says nothing about universalizing either the word street or the word vest. It says nothing about the idea that there is a universal pattern followed by vesting provisions generally. So one learns nothing, my respectful submission, from this case of assistance to my learned friend's argument.
And the oddity there is that the Turnpike Roads Act 1822, under which the trustees had acquired the road, gave them the full fee simple.
It gave the trustees the full fee simple.
Yes, do we know what that said?
We can perhaps look it up.
I mean, it's slightly historic, but it'd be quite interesting, because I mean, that's the oddity, is that they get far more than they actually need to maintain the road.
Yes. I mean, again, my Lord, one has to be cautious, because if one were here arguing afresh the Baird principle,
Oh, yes, I understand.
there are many points that could be made to suggest perhaps the law took a wrong turn, if I may speak bluntly, with Baird. But I'm not going there, obviously. And Lord Justice Romer makes similar points at page 1850. The defendants can only claim that the road in question here became vested in them in the full sense in which they seek to maintain that it's vested in them by relying on section 159. Now that section has received by this time an authoritative interpretation and so on.
But, am I right in understanding that what's being said is that the local authority took over responsibility for the entirety of the street under the Public Health Act, including the including the part of the street which had formerly been the turnpike, the effect of the Public Health Act was to vest in them only what was necessary for the ordinary user of the street, and that insofar as the turnpike trustees had a much more extensive right of property, that right of property did not pass to the local authority, but remained vested, for as far as one knows, in the trustees.
Exactly. That is exactly.
Which would be exactly the same result under this construction of Section 149, no matter who had owned the property before.
That is the point being
Normally the frontages, isn't it?
That is being made, the point being made by the court. You can't take an ambulatory view about how this section applies. It applies consistently. It goes no further than that. So that's the Finchley case. I'm not sure I actually need to show you the next case, but I need to refer to it. It's called Tithe Redemption Commission and Runcorn. It's in Volume 2, Tab 24. The memory stick is 1872. It does two things. It confirms that whatever the Highways Authority gets is a property interest recognised by the Land Registration Act and the Law of Property Act. It also applies the same reasoning that we've already seen to a statute that used the word road. Previously, we've always looked at streets. They were looking at county roads. And it's also the location of Lord Justice Denning's lively reference to the top two spits as the shorthand. But unless my learned friend wants me to turn it up at this stage, I for my part, don't think I need to do so. Then there is the case I mentioned of Blanchfield, which I think I ought to show you because it's a decision of the Privy Council. I appreciate that my learned friend hasn't relied on it, but the Court of Appeal has mentioned it. The way it arose is that, as I remember, Lord Justice Richards told us that his assistant had found it, and it's made its way into the judgment. We've put it into I've asked for it to be added to the supplementary authorities volume. It's at tab 40. Memory stick starts at memory stick 2240, but if your memory sticks haven't been updated, then I'm afraid that's possibly an idle reference. This was the case about whether the former occupants of Trinidad, or part of Trinidad, who had been displaced during the Second World War to make way for an American airbase, and their land had been compulsorily purchased with payment of compensation, did they have a right to have the land back once the airbase shut down? That was the question. One sees Lord Millett's approach starting at the foot of 2241, paragraph 5. The present proceedings were commenced in 1992 by way of motions for constitutional relief. The plaintiffs were descendants of landowners who had had their land compulsorily acquired in 1941. They sought declarations that the land in question had automatically reverted to them by operation of law in 1977 when the lease of the base was surrendered and the land was no longer required for the purpose for which it had been acquired. There's then a description of the land acquisition ordinances under which the land had been acquired in the 1940s, and a difference is pointed out between two different ordinances at the bottom of paragraph 7. The relevant difference is that under section 6 of one set of ordinances, it was provided that on publication the relevant notice of land should become vested in His Majesty the King, whereas in another ordinance it was provided that it should vest absolutely in the Crown. And Lord Millett said, well, the word absolutely adds nothing. But he then considered the interpretation of those provisions in some detail. The point which is of immediate relevance arises later in the reasoning at paragraph 15. He's dealing with the point that ordinarily in compulsory purchase, at least where you're not proceeding under the 1845 code, compulsory purchase is not accompanied by a right of reverter. That's the point in paragraph 14. And then in paragraph 15, he refers to an express provision for reverter that was made in the School Sites Act 1841, which gives rise to its own difficulties, but luckily we don't need to dwell on those. But this act was not concerned with compulsory purchase and is of only marginal relevance. Nevertheless, it confirms the rule that land conveyed for a particular purpose does not automatically revert to the grantor when the land ceases to be used for the purpose for which it was conveyed, even though land be conveyed for a particular purpose. In the absence of express provision to the contrary, it's to be taken to be conveyed in fee simple absolute and not for a determinable fee. And Lord Millett then says you can get help from the highways cases that I've looked at. This is the line of cases that I've shown you. And he says in paragraph 17, what these cases have in common is that the statute in question didn't say that the land should vest in the highway or other authority, but that the street should do so. Coverdale and Charlton held that these words had the effect of limiting the physical extent, so on. He says the decision itself was somewhat unsatisfactory, but in Mayor of Tunbridge Wells and Baird, the House of Lords confirmed that the statutory vesting of a street vested such property and such property only as is necessary for the control, protection or maintenance of the street as a highway. I think I can skip to 19, the last 4 lines. What does matter is that what brings the estate to an end is that given the description of the property as a street, the estate no longer has any physical content once the street has ceased to be used as a highway, but all this depends on the fact that when the relevant statute vests in the authority, that what the relevant statute vests in the authority is a street and not land. And then he contrasts that with what happened under his ordinances, where the word was land, and he says this is an additional indication that there was no reverter. Now, the Court of Appeal has referred to this speech, and so I need to make clear what I say about it. My submission is this. Lord Millett has here summarised the effect of the highways cases, but he has not displaced them. He hasn't professed to displace them. His point was that the ordinance he was construing did not provide for reverter. And in this it was unlike the highways legislation in England, which was a further reason why no reverter could be implied. I suggest that Lord Millett's description of the highways authorities is a shorthand sufficient for his purposes for what I have already said. Given the purpose of the vesting in section 263, which, as we've seen, was gleaned from far more than just the word highway or street or vest, nothing more than the Baird concept passed. I say it would be an exaggeration, and I suggest wrong, to say that this was because of the word street by itself, outside the particular vesting provision in question. And I don't accept that Lord Millett meant to suggest anything else, if that be the suggestion. My lady, may I then make 4 overall submissions about these authorities? First, the courts looking at this topic have recognised the question as one of statutory interpretation of an entire provision. That being what is now section 263. Secondly, no court in these cases, or any other of which I am aware, has professed to offer a general or common law definition of the word street or highway or any other noun, or for that matter, any other verb. Thirdly, one cannot separate what the judges have said about the word street from their views that only as much property should vest in the authority as was necessary for the stated statutory purposes. And this restrictive view is dependent on a purposive approach, taking a narrow view of the legislative purpose. the basic idea was to restrict what vested so as to be in some way commensurate with the subject matter of the authority's duty to repair, largely influenced by the principle against expropriation without compensation.
So the purpose for which the, whatever it was, the property was acquired, also translates into the legislative purpose.
It does seem to have been that. That seems
Seem
to
to
be
be
the
allied the two things.
It does seem to have been, well, I've shown your ladyship the authorities, that does seem to have been what happened. And it's given rise to problems in section 263, the conceptual problems that I've mentioned, but that is the approach that seems to have been taken. And the fourth submission is that the cases, if I may say so, quite clearly do not support the Court of Appeal's view that the word highway, in and of itself, communicates the bared concept.
Can I just ask in relation to your second principle, I thought we'd seen in Sylvain, for example, that there was a general common law definition of highway as effectively a right in the king's subjects to pass and repass.
Yes, we haven't specifically gone into that. I should clarify, I suppose, by what I mean by subparagraph 2, right, that the furthest one can get from the common law is the proposition that highway refers to the legal interest that the public possesses, yes, to pass and repass over land.
Oh, and the land over which the public
land
has that. I mean, it's not just the incorporeal right, because certainly in common parlance one refers to a highway as being a way over which the public has the right to pass and repass.
That is implicit in the legal. That's implicit in the legal right.
I'm not sure quite where that goes. I mean, it's an incorporeal right, I thought.
Yes.
But my lady's suggesting something more than that.
No, all I'm suggesting is that there is an incorporeal right in the public to pass and repass, but that right exists in relation to a physical space, yes, which is usually what is referred to as the highway.
Yes. Yes.
It must relate to a physical space. The problem is
the
common law doesn't tell you anything about what is associated with that right, where one has to identify the vertical column over which land affected by highway rights.
Well, generally at common law, dedications of highway didn't affect the ownership at all.
No, they didn't. That's exactly the point.
That's the underlying point.
Wasn't concerned with that question.
Yeah, it's analogous to a public right of way, I think.
It is a public right of way.
Well, effectively, public right of way is one's example of the other, perhaps. Yeah.
We're dealing with that class of public rights of way, particularly in relation to which the public has a duty to maintain.
Yeah.
There isn't always that duty, but we're dealing with that class of public right. So, my lady, that takes me to the second part of my...
That duty always arises from statute.
Yes. It does now. It didn't at common law. But it
At
does
common
now.
law, the inhabitants of the parish
Yes.
had
Since
to...
I think it was 1845, it's been a question of maybe in 1848. Anyway, since the middle of the 19th century, it's been a question.
But I mean, it's covered in the...
Yeah.
What you told us.
The second part of my submissions, then, if I may turn to that, is where I invite you to look at the limited definition we do have of highway, which is in the 1980 Act at section 328. Now, this is in volume 1 of the authorities. At tab 10. No, 11, I'm sorry. The memory stick page number is 1556. The heading holds out a great deal of promise, which sadly is not fulfilled. Heading is meaning of highway, subsection 1, in this act, except where the context otherwise requires, highway means the whole or a part of a highway other than a ferry or waterway. So one can see why...
I'm sorry, the reference, please.
It's MS 1556.
Thank
I'm
you.
so sorry, I probably skipped
Entirely my fault. Thank you.
1556.
Thank you.
So it has that degree of circularity, which is quite unhelpful. There are 2 points that one can emphasise and that might be helpful as the court reflects on this question. The first is to notice the exception, except where the context otherwise requires. When one thinks about it, that is actually an enjoinder. It's telling whoever has to read the word highway that there's no easy way out. You do have to consider the context. The second point of some interest is that highway might mean the whole of a highway, or it might mean part of a highway. I mention that because it's not impossible to read the section to read sections 263 as being a case where only part of the highway vests. That part which is necessary and so on to use the Baird concept. That's not an impossible reading. So there are 2 alternatives. One is that when you look at section 263 in its context, it has the particular meaning that the courts have given to it, rather than some hypothetical other meaning. And the other is that if there is some larger meaning of the word highway, in section 263, nevertheless, only part of the highway is what vests. So my interpretation and the court's interpretation of section 263 doesn't in any way offend the definition such that it is in section 328. Equally, neither does our interpretation of section 265. There are 2 ways of looking at highway in section 265. Either if you start with the presumption that highway has this narrow meaning, you nevertheless need to see whether the context requires you to adopt another meaning.
3282 presumably rather confirms the common law meaning, because it says that where the way passes over a bridge, then you need statutory extension to ensure that that includes the bridge.
Well, you can look at it in one of 2 ways. Either it's to do something that wouldn't otherwise be understood, or it's to make clear what would be understood and to draw a limit around what passes as the highway. Where it's going through a tunnel, all you get, all that vests is the tunnel. The other provision I need to show you, of course, is section 263 itself. This is at memory stick 1526. And it's in a form that's familiar. It very substantially repeats the forms we find in the 19th century and considered in the cases, but it substitutes the word highway for the use of the word street or road. That's really the main difference. Now, I'm not going to suggest that swapping highway for street means that for that reason you can disregard everything that's been said. But I think I am entitled to make this slightly more subtle point. The fact that the draftsman felt able to make this substitution without jeopardizing the Baird concept tells you that he recognized that the Baird concept is based on a broader principle of statutory interpretation. It is not linked to any particular noun or indeed any particular verb. It's linked to the purpose achieved by this provision. The related point I can make derives from the fact that the drafting has preserved the reference to every highway maintainable at the public expense. It's maintained the concept, the trigger point. What is it that attracts this provision? It's the duty to maintain. That is the crucial link with the old cases. And the other linguistic link that the draftsman has preserved is vest as the operative verb. Now, both those sections, both section 263 and section 328, are unchanged in any material way from the form they first took in the Highways Act 1959.
Do we get any help from 2634, where we get the concept of transferring of property?
I haven't reflected on that. Let me see. Where the responsibility for the maintenance of a bridge is transferred, property in it is not so transferred. I think I'll have to reflect on that, my lord. And maybe over lunch we can reflect on it, rather than on my hoof.
Well, one of the points we're making is the distinction between vesting and transferring.
Yes, it is.
Here you get the two in one section.
That's right, but I hadn't spotted that point, so I'll have to come back to it. I was going to go to the 1959 Act because it's in the 1959 Act that we find these two provisions in their modern form. Can I just locate the references first of all? What is now section 328 was formerly section 294. Which is at memory stick 1407. Your ladyship sees that although there's no subsection 4, subsection 1 is, I think, the same, subsection 2 is, these are substantially the same provisions. And what is now section 263 used to be section 226, which we can find at page 1402. Again, this is where one would expect to find that subsection my Lord Carnwath referred to a moment ago, and here we don't find that. Oh, yes, we do. It's in subsection 3. But anyway, this is substantially in the same form. I believe it is actually the same form as the 1980 Act. And I mention the 1959 Act as having some potential importance because it's the origin of the current wording, and we have the benefit of some insight into its background. A draft of the 1959 bill was referred to a committee of experts of recognised authority on the subject, as the government put it, who published a report. We've got extracts of this report in the bundle. We've referred to it in our printed case in Annex 1, paragraph 20. There's an additional one page I need to add, if I may, and I'll just give you the reference. It's in the Supplementary Authorities bundle, tab 41. Memory stick, if we ever get it, is 2248. Now, before I show you this material, I need to do a slightly complicated explanation. The draft bill became the Act, with one exception, which has slightly complicated the numbering. Clauses 1 to 119 of the draft bill became sections 1 to 119 of the Act. But section 120 of the Act, which is about damage to the highway, is an addition that has no equivalent in the draft bill. So for every reference to a clause of the draft bill after clause 119, we have to add one.
That's much easier than it often is.
Yes.
Most bills go through far more than that.
Anyway, did the committee say anything about the mischief and general purpose to which these two provisions were directed? And we say yes. And let me show you. Can I ask you to go to volume 3, tab 33, memory stick 2109. This is that report one sees on the next page.
5 or 9, I'm sorry.
2109, my lady.
I heard the vowel but not the consonants.
At 2110, we see the members of the committee under the Marquess of Reading. There was some legal presence. A.J. Irvine, Queen's Counsel, he then was. And then some solicitors and remembrances. I noticed that the Corporation of London was represented, for example, and a Deputy Counsel from the Office of the Parliamentary Counsel to the Treasury, and representatives from other interested bodies. So this is the report of the Committee of Experts, which would describe their task at page 2114. To the Right Honourable Henry Brooke, Minister of Housing and Local Government, we were appointed by you on the 25th of February 1958 to be a committee with the following terms of reference: to examine with a view to consolidation the public general enactments relating to highways, streets and bridges in England and Wales, other than enactments designed to regulate traffic or applying exclusively to London, to consider which of the enactments should be consolidated and what amendments not of substantial importance, including consequential amendments of the common law and the general enactment of non-controversial provisions commonly found in local acts, are desirable in connection with the consolidation, either to improve the form of the law or for the removal of anomalies, inconsistencies and ambiguities, for abrogating and so on. So that's the description of their terms of reference, and one notices, and this was picked up in our annex, the 1959 Act, though largely consolidating, was not entirely so.
It's really rather like what happened when the Law Commission came along and one had this power to introduce amendments.
I suggest it is that this material is very closely analogous to the product of a Law Commission investigation. The passages that I'd like particularly to refer to the court begin with page 2163, where we find, under paragraph 135, commentary on vesting of highways. They're talking about clause 225. Now, that is what became section 226 and is now section 263. So it's the provision with the pedigree that we've looked at in the 19th century cases and is now section 263 of the 1980 Act, in the same form of words. Clause 225 vests every highway maintainable at the public expense in the authority, who are, for the time being, the highway authority for the highway. The Parish Councils Association suggested that this was an unnecessary provision which might create unforeseeable difficulties, especially in relation to footpaths. They therefore urged that footpaths should be accepted from this provision. We do not share this view, which we feel may be based on a misconception as to the purpose and effect of the clause. The enactments reproduced in the clause have frequently been considered by the courts, and it has been held that they vest in the highway authority the property and the surface of the highway, and in so much of the actual soil below and the air above as may reasonably be required for its control, protection and maintenance as a highway. It seems to us, therefore, that it is just as necessary that footpaths, which are highways maintainable at the public expense, shall vest in the highway authority as any other highway so maintainable. Your Ladyship appreciates the point here is we gain insight into how the draftsman and the committee understood this vesting provision. It's not a function of the word street or of any particular noun or verb. They recognised that the learning concerned the effect of the clause as a whole. Secondly, in an appendix, the committee made some explanatory remarks about particular provisions in the draft bill, sadly not all of them, but they did include some remarks about the definition of highway, which I've shown you. This starts at 2177, lady, right at the foot of the page. And we see they start by talking about highway in terms of its incorporeal character, the legal right. The right of navigation over the sea and certain inland waters is a right of way, a highway of water or waterway. They are using the word highway there in the common law sense, primarily, of describing an incorporeal right. They give the example of a ferry which forms a link between the termination of a highway on one side of a river or other water and the recommencement of the highway on the other side is regarded as part of the continuous highway across the water. Virtually all the enactments reproduced in the draft bill are concerned only with highways over land. And it is therefore necessary, having regard to the nature of waterways and ferries, to exclude them. So that explains why we find those words in the definition. But you see that already we can see the committee using the word highway in this protean, recognising its protean qualities, because they now start seamlessly to talk about highways in a physical sense in association with bridges. Highways and bridges were, as a rule, dealt with separately in the earlier acts. There's reference to a definition of highways in the 1835 Act to include bridges other than county bridges, and all the modern acts define road, the word most frequently used, as meaning a highway. And so we find highways here being used in a more physical sense. Then there is reference to the relationship between a highway and a tunnel in the following paragraph. And then in the next paragraph, further reference to the relationship between a highway and a bridge. And at this point, at the top of page 2179, one can see the committee almost saying, perhaps this is too extreme a paraphrase, but it's saying, let's not get too fixated on the particular word.
But you really like the sentence at the top of...
I do like it.
You really, really like that, don't you?
Yeah. I'd better read it just so that I don't want to leave anyone who can't read the text hanging about this important sentence. It is hoped that this makes it as clear as possible that highway, when it occurs in the draft bill, must not simply be taken in its ordinary sense. They don't actually say what the ordinary sense is, but it mustn't simply be taken in its ordinary sense, but must be regarded as embracing a number of possibilities. It may, for example, have to be taken as referring simply to a bridge or even a part only of a bridge, thus where a highway carried by a bridge is maintainable by a private person, but the bridge is maintainable by the highway authority, the bridge in itself will constitute a highway maintainable at the public expense. I appreciate that the example they give is linked to bridges, but the principle they are asking you to adopt, they are asking the reader to recognise, that's a better way to put it, is that the word highway needs to be viewed in its context each time it's used. Still on this page, I come now to a slightly obscure point which I hadn't noticed when I wrote the printed case, but I want to add it. There is one further matter to be noted in connection with this clause. They refer to previous definitions of a road as including a proposed road. That is to say, land on which a highway authority are for the time being constructing or intending to construct a highway. that the land does not become a proposed road until plans for the construction of the highway have been made or approved by the minister. And they refer to difficulties in the current bill associated with that. And so they say, accordingly, in the various clauses where it's correct to do so, either there's a specific reference to a proposed highway or effect is otherwise given to the definition of road mentioned above. Now, the draft bill contained a definition of proposed highway. That's what I asked to be added to the supplementary bundle, which we can now we can find right at the end. The memory stick is 2248. And the definition tracks closely the committee's language in that passage I've read. If your ladyship has that at tab 41 in this supplementary volume, proposed highway means land on which, in accordance with plans made or approved by the minister, a highway authority are for the time being constructing or intending to construct a highway shown in the plans. Milady, that definition, without any material change, has carried forward into the 1980 Act. If you'd like to locate that, it's in volume 1 at tab 11. MS 1568. It now means land on which, in accordance with plans made by a highway authority, that authority are for the time being constructing or intending to construct a highway shown in the plans. I've got just 2 points to make about that, one of which is shorter than the other. The short point is to draw attention to how naturally that definition flows from the word proposed and the word highway. Land on which the authority are constructing or intending to construct a highway. It's no less natural if you strike out the word proposed. Strike out the word proposed. What are you left with? The land on which the authority has constructed a highway. What's wrong with that? I'm not saying that is the general meaning of highway. It goes to my point that the word highway itself is a sufficiently protean creature to lend itself naturally to that kind of usage. The second point is slightly more involved. It involves taking us to some of the provisions in the 1980 Act which were introduced by the Greater London Authority Act 1999. And I need to show you the powers under which our transfer order was made. Can I ask you to go in tab 11 back to page 1443? The first stage, as you'll remember from the way the statutory framework was described in the courts below, the first stage is that the Secretary of State designates the highways which are to be GLA roads. But your ladyship sees that power relates not only to highways, but proposed highways. In section 14D, capital D, on page 1449, we find this requirement. Any reference in any provision of this Act or any other enactment to a GLA road shall be construed as a reference to a highway or proposed highway in Greater London. Which is for the time being a GLA road by virtue of, and in our case what matters is B, an order made by the Secretary of State under section 14A. If one reflects on the implications of that for a moment, I ask you to have in mind the example given by Mr. Justice Mann in paragraph 40 of his judgment. You remember he was there dealing with the anomaly that arises on the council's case. He was putting forward the situation where TfL only gets the top 2 spits under paragraph A. But next to the road, parallel to it, it owns other property. Let's take the example of a depot, or land on which some other highways function is being discharged. Under paragraph B, TfL gets the whole property interest in that. Justice Mann struggled to find any intelligible reason why that should be so. The passages I've just shown you is that the problem is even more acute than that. If you have a stretch of unfinished road, the Court of Appeal is right. The TfL gets only the top 2 spits in relation to the bit that's been finished, but it gets the whole interest, the land on which it is proposed to construct, the rest of the road. So that is Mr. Justice Mann's point made with exponentially more force. It makes no sense that the Secretary of State had power to make an order relating to proposed roads which would have a different effect in relation to the bit where there was still only a proposal compared to the bit which had already been built out. Anyway, let me then turn to section 265. I have postponed looking at this section in the hope that it will now be easier to analyse its key features. But I can't put it off any longer. May I ask the Court to go to memory stick page 1531. We're back in volume 1 at tab 11. Section 265 is headed Transfer of Property and Liabilities upon a highway becoming or ceasing to be a trunk road. And we see from subsection 1 that where a highway becomes a trunk road, then subject to the provisions of this section, as from the date on which the highway becomes a trunk road, the operative date, there are transferred to the Minister or the Strategic Highways Company, whichever is highway authority for the trunk road, by virtue of this section, A, the highway insofar as immediately before the operative date it was vested in the former highway authority, and B, the property mentioned in subsection 3 below, insofar as immediately before the operative date it was vested in the former highway authority for the purposes of their functions in relation to the highway. We don't need the next bit, I don't think. And then C, all liabilities incurred by any such authority or council for the purposes of their functions in relation to the highway and not discharged before the operative date other than loans and loan charges. And, we mustn't forget this sentence, and the highway and other property so that transferred vest by virtue of this section in the Minister or the company. Before we go on to the rest of this section, may I make my submissions about what's seen on this page? The first is that we see from subsection 1, and as is obvious, this section is dealing with a different factual situation from the one dealt with by section 265. We're not concerned with the vesting for the first time in a highways authority of an interest as a result of its duty to maintain. We are concerned with transferring from one highways authority to another property. There are no words linking the vesting to the duty to repair. Those words relating to maintenance are deliberately omitted, presumably, from section 265. So that big clue that big clue which was so influential in the interpretation about section 263 is missing. Secondly, I've drawn attention to the fact that the verb used is transfer, not vest, but I'll return to that in a moment, if I may. The third point is that what vests is not the street or the road or the highway, but this expanded expression, the highway. I'm reading now paragraph A, the highway insofar as immediately before the operative date it was vested in the former highway authority. I commend to the court what Mr. Mayle said about this, starting at paragraph 108. Now, this is in memory stick page 217 to 218. It's otherwise Appendix Volume 2A. I don't think it is.
No, it isn't in the... It isn't.
I wish I'd asked it to go in, because I can never find it.
It's in 2A.
It's in 2A.
Quite long.
Well, it is long, yes.
It would have made the core bundle rather larger than we normally like to have it.
Yes, that's the point.
Well, not all of this is taken up with the award, but anyway, I'm not going to, at this stage, to ask you to read the whole of the award. I'm going to confine myself to paragraphs 108 to 111. These are memory stick 217.
217.
Internal page numbering 80. The words used. The arbitrator says paragraph A doesn't...
I'm sorry, you're going to have to help me. This is Appendix 2A.
My lord, yes. Does yours have the memory stick numbers
Probably.
at the bottom of the page? Mine
No,
doesn't.
they usually don't.
In that case,
Page 80 at the bottom.
it's page 80.
Thank you very much.
In bold.
Yes, thank you.
So the arbitrator says about paragraph A that it doesn't operate to transfer just the highway. It operates to transfer the highway insofar as it's vested in the former highway authority. The council's arguments don't really address the significance of these emphasised words. Pointed out that we relied on them. We say these words make expressly clear that TfL should step fully into the shoes of the former highway authority so far as concerns the ownership and its highway and its ownership. I agree. I, of course, maintain that submission. So if the former authority only owned the top two spits, that is what would transfer. If the former authority owned the top two spits and the necessary land, that was his expression for the Baird concept, then that is what would transfer. If the former highway authority owned the top two spits, the necessary land and subsoil and airspace above and below, then that is what would transfer to TfL. Actually, I've done him an injustice. He distinguishes between the top two spits and the bits above and below the top two spits, which he calls the necessary land. He says, it seems to me that in the context of a transfer of property order, the emphasised words direct an inquiry as to what property was vested in the former highway authority by way of ownership of the relevant road. In the context of a transfer of property order, it seems to me that the word highway read together with the emphasised words is being used not in a technical sense as in Baird, but in the way of identifying a particular piece of property. So whatever interest the council's owned in the relevant highway, then that is what interest was vested in the former highway authority. That interest is what was vested, and that interest is what was transferred. So far, so good. But he then makes this important, I suggest, forensic point. It seems to me that on the council's case, the words insofar as it is vested in the former highway authority are otiose. I say this because, applying Baird, the top two spits are vested in the former highway authority. So also is any land necessary for the control, protection and maintenance of the GLA roads as a highway, i.e. what I have been calling the necessary land. Consequently, on the council's case, there is no need to refer to what is vested in the former highway authority. On the council's case, paragraph A would simply refer to the highway. And that is correct. That is a correct point of language and logic and coherence.
Subject to the usual dangers of arguing from redundancy.
Subject to that. I accept that. I do accept that. That is a danger. But as I'm going to show you in a moment, my lord, this provision sits within a structure in section 265, which I suggest fits entirely with what Mr. Mayle has there said. But I'll come to that in a moment. So we say that the arbitrator correctly located and explained the effect of those words. There is another similar point, which, again, I'm afraid has only struck me recently. If you remind yourselves of paragraph A compared with paragraph B, you'll see that when we're looking at the property described in paragraph B, what gets vested in the incoming authority is such property as was vested in the old one for the purposes of their functions in relation to the highway. So those words qualify what vests under B, but they don't qualify what vests under A. Now, one explanation for that, and I suggest a good one, is that the draftsman deliberately isolated paragraph A from all these historical arguments about how much of the subsoil, how high the column of airspace was that vested. It isn't about that question. It simply asks you to identify the route of the highway and the interest that the Highways Authority had in that route. Whatever that is, gets transferred to the incoming authority. My next point relates to those closing words of subsection 1, and the highway and other property so transferred. Those words recognise highway as part of the genus of property. That is significant for 3 reasons. First, when we look at subsection 5, we will find that there is power between the minister and the former authority to agree to retransferring any property. So there's an opportunity, unlike in section 263, to tailor the operation of section 265 to deal with special cases, the unexpected case. Section 265 can therefore be seen as dealing with the paradigm situation. If there's some complication, which means that the incoming authority would get too much if you take the default approach, that can be dealt with by agreement. It has to be by agreement. That's the first point. The second point is that when we stand back and look at the structure of section 265, we will see the importance of recognising that the highway is a species of property. I flagged that point up, but I'm going to say something about structure separately in a moment. The third point is that seeing the highway recognised as a species of property lets me come back to this question of the word transfer. Because you remember what Lord Justice Bramwell said in Coverdale about the possibility that the word transfer might have had a clearer or different meaning compared with the word vest. And you've heard me make the submission that vest can perhaps more easily describe the creation of a new interest where previously there was only one undivided interest, such as the kind of flying freehold that results from the council's approach. We say it's harder to get that from transfer. And the practical implications of this are dealt with in Mr. Mayle's award at paragraphs 117 to 118. I don't know if you still have that open. If not, may I ask you to go back to Appendix Part 2A. The memory stick number, I think, is 219. The internal number is 82. As to the provisions of the transfer order, I'm reading from paragraph 116, I'm sorry. As to the provisions of the transfer order, it seems to me that the purpose underlying the order was that so far as the GLA roads are concerned, TfL should step fully into the shoes of the former highway authority. It strikes me as unlikely that Parliament intended that if, prior to the transfer order, there was one authority owning the property in the GLA roads, after the transfer order there would be two authorities, each owning different layers of property in those roads. In this regard, the order which I am concerned with is called a transfer of property order. It is concerned with the transfer of existing interests in property. It is not concerned with the creation of new interests in property. Yet if the councils are correct in their case on paragraph A, the effect of the order is to create new layers of property interests above and below the GLA roads. Rather than being a transfer of property order, it is a creation of interests in property order. Effectively, on the council's case, the transfer order created a whole raft of flying freeholds above and below certain GLA roads. Furthermore, those flying freeholds are not defined by reference to specific and definite criteria. Instead, they're defined by what is necessary for highways purposes. Under the transfer order, the necessity would have to be judged as at 2000, but what is necessary for highway purposes could change from time to time. Yet on the council's case, one would apply the Baird test of what is necessary for highways purposes as at 2000, and it would be set in stone thereafter. He's making the point that the councils are asking you to accelerate the moment artificially at which one has to work out how tall is this column of land. And there's no justification for that at all in the order. If what was necessary for highways purposes changed thereafter and, say, further airspace was acquired, then TfL would have to seek the council's agreement to use that airspace. Mr. Elvin's response is, so what? They've got powers of compulsory purchase. That's a completely inadequate response. Plainly. The arbitrator thinks the same. I think he's more modest than me. He says, I think it unlikely that Parliament intended such a result. It's clearly not a result that Parliament could have intended. Mr. Justice Mann made a similar point in paragraph 38. This is in the core volume, memory stick page 176. Paragraph 38. A further aspect of the point is another made by the arbitrator. He then, I think he's making the point that I've just read to the court. He acknowledges halfway down the paragraph, does your ladyship have this? I acknowledge, of course, that there remains the possibility of this sort of split holding where the highway authority may not hold the entire land qua highway authority, but that does no more than reflect the sort of situation which exists in dedication like Bayliss. It doesn't mean that Parliament intended to create the potential for layering on as wide a scale as Mr. Elvin's submissions would give rise to. That's our point. We're not saying Section 265 is a cure for everything. We are saying it doesn't make things worse or more complicated for the incoming authority than they were for the old one. So it's no answer, it's irrelevant for Mr. Elvin to have said, well, there are complications anyway. Of course there are. That's no justification for adding to the complexity. So those are the points that the arbitrator and Mr. Justice Mann made, essentially flowing from the difference between, or at least related to, the significance of the word transfer. Not creating a new interest. I have found, I'm afraid, belatedly, one authority which might shed light on this. I'm not saying it's a knockdown point, but I think I ought to show it to you. We asked for it to be distributed before coming into court, and I hope it's...
Whom does it not knock down?
Beg your pardon?
Whom does it not knock down?
Either. I'm not saying it's a knockdown argument in my favour, but I think it's right that your ladyship should... I should show it to your ladyship. It's this case called the Queen on the application of the Lord Chancellor and the Chief Land Registrar. I'd better give the reference because it's not in any paginated form. It's 2006 QB 795. and it was the case that arose about the transfer of magistrates' courts, which gave rise to quite a lot of difficulty, as I recall. And we see from the headnote that the Lord Chancellor got a power to make a scheme for the transfer to him or another minister of any property rights or liabilities to which magistrates' courts committees were entitled or subject. Your Ladyship sees from the headnote, dismissing the claim, that the power conferred by Parliament on the Lord Chancellor to transfer property was not a power to create or grant a new property interest, but a transfer of property with the meaning of the 2003 Act meant a non-physical transfer of the bundle of rights and obligations relating to a building, in distinction to the creation of a lease, which subjected the lessor's rights to those of the lessee without any transfer of rights or obligations. So the subject matter, of course, is different. But the reasoning of the judge, Mr. Justice Stanley Burnton, you might nevertheless find helpful, starting at paragraph 22. Words property and transfer are not defined in the Act. Mr. Mould submitted that, giving the statute a broad practical and purposive construction, the grant by a local authority to a minister of a lease of a magistrate's court for a term of 999 years at a peppercorn rent is a transfer of the magistrate's court. As Mr. Mould accepted, the Lord Chancellor's contention involves reading the word property as meaning premises or building, or that part of the building that is used as a magistrate's court, rather than its normal legal sense. I accept that colloquially the word property may be used in the sense contended for, but that is not a colloquial context. Mr. Mould couldn't point to any other statute in which the word property has been used to mean building or premises. He makes a comparison with a different provision, and he says in paragraph 24, and this is really what I'm getting at, my lady, there is an obvious difference between the transfer of property and the creation or grant of a new property interest. If Parliament had intended there to be a power to grant leases, different words were required and would have been used. And he makes a comparison with other provisions. And in paragraph 25, I won't read it out, but you might like to read that. So there is some, I don't say it's all that weighty, but it is some fortification for the submission I made about how one should understand Lord Justice Bramwell's dictum in Coverdale. It would have been clearer if transfer had been used, because that more than vest, at any event, would have indicated an intention to convey an existing property interest, something that already existed, as distinct from creating something else. Returning to, just check that I've covered the points at page 1531 and 1532. I must show you on 1532 the property which gets transferred by paragraph B, and your ladyship sees its land, other than land vested in the former highway authority for the purpose of being used, and so on. So there are these limited exceptions, and in paragraph B of subsection 3, all other property, again subject to certain exceptions.
Can I just ask a bit more about this? B then would cover, for example, offices that were held by the highway authority for the purpose of performing their functions. And if they had a yard where they kept, I don't know, gritting lorries or grit itself, for example, which was dedicated to a GLA road, then that would be carried as well. Now, it's really more a matter for Mr. Elvin, but I'm slightly puzzled as to why on his argument, the land below the two spits depth wouldn't be carried. I presume the argument is that it's not held by the highway authority for the purpose for its highway, for the purposes of its highway functions.
I think, my lord, your lordship goes to the heart of it, and that's why we're spending so much time on this point. It comes down possibly to what may turn out on the facts to be quite a narrow point, because there may be many situations, I don't know this, but there may be situations where these councils will accept that the subsoil underneath a highway is held by them for highways functions in relation to that highway, in which case, on any view, it would pass under B. The problem is that with that approach, we have potentially in relation to many sections of the highway, certainly with these two councils, we have a complicated, potentially factual inquiry to make, potentially going back into the history relating to the acquisition of these different interests, and it's going to be said that there are factors which show, maybe despite outward appearances, I don't know because this has been dealt with as preliminary issues, but it may be said even despite outward appearances, the subsoil is not actually held for highways functions, and that is why it has become important for us to isolate the effect of paragraph A as distinct from paragraph B. But my lord, your lordship is right to flag up the point. It may, on the facts, turn out to be a narrow difference.
Can I, so I don't try to understand that. You're saying that if it's clear that the London Borough of Southwark, for example, has acquired land to build a road under its highway powers and holds the land up and down in the traditional sense for that purpose, then that will be transferred under B.
May I make the position clear through my submissions about the structure of this?
I mean, I'm just wondering what is common ground, not so much what you're saying. But
what Mr. Elvin would say is that potentially that is correct, but subject to us showing that the subsoil is held for highways purposes. I hope I'm not mischaracterising his submission. Our submission is that if we lose this appeal, that's correct.
Yeah, and then you'll have to spend a lot of time working out what is what.
Yeah, but that, we say, is actually not a true interpretation of this.
Yes, but I mean, what's in it all commercially? I mean, you know, you got an answer from the arbitrator, which obviously you liked, and that was upheld in the High Court, but clearly something persuaded the authorities that they needed, for good reasons, to go further. Well, what's in it sort of commercially for them?
I don't know in full detail what the underlying money factors are. And we dealt with as a preliminary.
I'm putting you a question which is ready for Mr. Elvin, and no doubt he will answer it.
My understanding is that this issue has more money value in relation to the airspace than in relation to the subsoil. That's my understanding. But I'm not sure.
That was my guess.
Yeah, I'm not sure I can offer you a fully particularised example of how this might crop up. But my understanding is that the money in this case lies in who controls the airspace, the surface above the highway, who has the power effectively to monetise the airspace or bits of the airspace.
I assume you say that the principle which you're here looking at applies as much to airspace as subsoil.
That's exactly the point.
If under a CPO you require airspace all up to the firmament, then you're holding it for a highway.
It does. There's no difference.
Even if above the level of a double-decker bus, that seems rather important.
They're just, yes, they are different descriptions of the same column. They're different parts of the same column.
They're all part of the vertical plane.
Yes.
I mean, the concept of land being held by a statutory authority for a purpose would normally apply, as my lord says, to the land in its traditional sense.
Well, quite. It's only because of the Baird concept that we're having to grapple with this issue at all. But I said that well, I'm going to say the better way of approaching this is by standing back and looking at the structure. And my submissions are, it is really an aspect of the language. We've made this point in paragraph 38 of our printed case. But let me just do what I can to summarise it here. We say that the structure is both straightforward and intelligible. Paragraph A transfers whatever interest the outgoing authority has in the actual route of the highway. Subject to the stated exceptions, paragraph B transfers any other property held by the outgoing authority for highways purposes in relation to the highway in question, including land which is remote from the highway. The purpose of paragraph B is to capture lateral, can I call it that, lateral land. The route is covered by A. I have to say, I think this is a pretty obvious point, if I may speak bluntly. And I'm going to make this further suggestion, which I'm afraid is not in my case, because it's only just struck me. If I'm wrong about that, then it is impossible to see why paragraph A was enacted.
Yes.
Because in every case, these top two spits would pass under B. Court of Appeal's approach denudes paragraph A of all effect. It contributes nothing. And there's a final linguistic point, which we shouldn't overlook. Section 263, which is what carries this whole body of learning about the Baird concept, is explicitly disapplied from section 265. You get that when we look back at section 263. Subsection 2 provides subsection 1 does not apply to a highway with respect to the vesting of which, on its becoming or ceasing to be a trunk road, provision is made by section 265. The Court of Appeal asked why the draftsman hadn't made clear his intention to apply some different meaning from the Baird concept. I have to ask, how much clearer could he have been? He has expressly dislocated the learning relating to section 263 from section 265. My lady, if that's a convenient moment.
Looks very convenient to me, according to the clock on my computer. Well, we'll adjourn now and look forward to hearing from you again at 2:00.